Good day, Crime Talk aficionados. This is Scott Reisch for Crime Talk, and thank you for watching. We have a big docket today, so let's get to it. First, another Lori Vallow update. Searches of electronic devices has begun. Second, an Ahmaud Arbery update. Third, the Louisville, Kentucky Police Department does a no-knock raid. Turns out to be the wrong house. And they charge the guy inside that shoots at the police with attempted murder. And oh, by the way, the police kill someone else in the house. Next, a 32-year-old murder in Australia of an American citizen. Someone has finally been charged. A 5-year-old driver proves dreams do come true, and our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch from Crime Talk, and thank you for watching. As you know, if you have not already done so, please hit that subscribe button. Hit the like button as well, and leave us a comment below about what you think about the topics we discussed today. First on the docket, Lori Vallow. For those who do not know, Lori Vallow is in custody in Idaho under charges of desertion related to her non-production of 2 of her children. She has tried repeatedly to have her bond reduced. Once when she was arrested in Hawaii, after she was extradited back to Idaho, she had her bond reduced from $5 million to $1 million, and a hearing less than 2 weeks ago, it was denied yet again. Well, the defense in this particular case filed some very perfunctory boilerplate discovery motions, basically saying, turn over everything that you have. And specifically, it was related to the calls, which were the issue at the bond reduction hearing, that the judge really said, your remedy for the jail listening to calls inadvertently is to have those statements suppressed at a future court date. It's not really a basis for a bond reduction motion. I think I maybe try to understand what the attorney for Ms. Vallow is trying to do. He was trying to make some hay out of it. Been there, done that. We've all, as an attorney, had to try and do something, even though you know you're going to lose, you do it anyway. But in one of the responses that the prosecutor filed late yesterday was the response to the defendant's discovery request. And in particular, there was a request of any and all records, recordings, documents, written evidence, photographs, videos, records, reports, text, emails, financial, computer records stored, obtained, computer forensic reports of any and all electronic devices. And the response is what is the interesting part. The state will send its mailed response, the Celebrite phone records of individuals and items listed in the party's stipulation on filter review, which the state will file with this disclosure. Buried at the back of the responses was a stipulation for filter review. So we know that various items are going off to Celebrite. Celebrite is a company that has some software that basically you can plug it in their machine, and it downloads everything on the computer, and it's massive. They print out everything, where you've been, you can get it all depending upon the warrant. Usually if it's a consensual search, you get everything. Now there's some really good case law out there for the defense, and we've won a lot of these lately because the detectives go and basically do a general warrant. They say, we want to search your phone. You can't do that. It's a general warrant, which is prohibited under the Fourth Amendment. So you have to be very specific and really kind of know what you're looking for, because they don't get to go through the phone just rummaging around saying, we're not sure what the hell we're looking for, but we'll know it when we find it. Doesn't work that way. Well, in this particular case, it says the state of Idaho, by and through the Madison County Prosecutor's Office and the defendant, by and through her attorney, Mark L. Means, hereby agree and stipulate as follows. 1. Whereas the following items were seized from the defendant pursuant to a search warrant: an Apple iPad with initials JJ on the back, Apple iPad in blue and green protective case, Apple iPad in purple and aqua protective case, Apple laptop computer, HP laptop computer, HP laptop computer, PNY 256 gig USB drive, and an Apple iPhone 6 seized after the defendant's arrest. There's a stipulation here that both parties concede that there may be privileged communications with defense counsel. And the state's filing a motion for a filter review and asks that the court authorize Special Agent Brad Rodel of the United States Department of Homeland Security to perform a review of the listed items and then provide forensic analysis of those devices to the state wherein any privileged communications were removed. The state and defense have previously discussed providing the filtered analysis to a special master for further review. The parties now agree that the state will provide those materials to the defendant through discovery without further review by a special master. In the event that either party finds any communication between the defendant and legal counsel on the listed devices that may not have been removed by the filter review, the party finding said information shall immediately report the communication to the other party. So what does that mean? And we've touched on it a little bit the other day. The attorney-client communication privilege. Not only is it related to what is discussed in person, but also communications back and forth through whatever means. And so whether the defense has put the state on notice or they have already found items that would be with counsel, the state is not going to be able to use those privileged communications in the case as it relates to Miss Vallow. So even if the phone dumps or searches of all these computers were to turn up information and nobody claimed privilege, the privilege could still be asserted, and they would have to create what they refer to as a privilege log. And you would have to identify what items are identified, what privilege you think they are, whether they're attorney-client or doctor-patient or something along those lines, and the basis for that. And even if the prosecutor knew what was said in those items, none of that information could be used because it was obtained basically through attorney-client communications. This is frankly one of the big problems I have today, why I don't like using text messages with clients, because it's much harder to assert attorney-client privilege to those types of items. And not everything from your attorney is attorney-client privilege. So there could be lots of issues related to these communications between Ms. Vallow and her attorneys. It's going to be interesting to watch because at some point there may be some communication back and forth, basically about why didn't you turn over the kids, or legal strategy, things of that nature. Now, the prosecutor shouldn't necessarily get them anyway, but they certainly aren't going to be able to use them. So once again, a case gets even more convoluted, and hopefully the attorneys communicated appropriately, perhaps on letterhead, which seems like a lot of people don't like to do these days. Everybody likes to send emails. I'm an old-fashioned guy. Attach a real letter to an email so it looks official and not just some casual conversation between you and the attorney. Just saying. We'll see how it turns out. Next on the docket, Ahmaud Arbery. Quick case update. We mentioned yesterday that the autopsy of Mr. Arbery had been released. It confirmed that he had been shot in the chest twice and once in the wrist, more of a grazing wound type situation. But I thought also significant, because this is what people always look at when you get the autopsy review, is what was the alcohol or drugs that were tested for. In this particular case, they all came back negative on the standard screen that the coroner did in this particular case. I think that's worth noting, and frankly, had Mr. Arbery been on any substances, we would have let you know about that as well. It's called fairness. Now, the McMichaels are still in the Glenn County Detention Center, and they're both being held in protective custody. Apparently, representatives from the detention center would not say whether the gentlemen were on a suicide watch or whether they were there for their own protection as to whether any threats had been made to them. Now, it's not uncommon in a high-profile case for a defendant or defendants in this particular case to be kept in protective custody because, given the fact that the father, Mr. McMichaels, was a police officer and worked for the district attorney's office, he may have some problems. He would be an easy target. Given the high-profile nature of this case, the sheriff has a duty to protect everybody in the jail from assaults. Frankly, it probably goes up a little bit when you know somebody may be a target of being assaulted. So we'll see as things progress when an indictment is brought down and if, in fact, bail will be reduced as both are being held on a no bond hold. Now, on one of the weirder notes of any case, and this could be absolutely nothing or it could be significant, there was a note found at a memorial for Mr. Arbery, and it said, "I am so sorry. I should have stopped them. I am so sorry." Now, could that just be somebody putting a card out there and expressing general remorse for the situation? Yes. Could it also mean that there was potentially another witness who may have seen what was going on? Now, obviously, there's a video, except for a portion where it goes off to the left of the screen of the camera, so to speak, and you cannot necessarily see this alleged struggle for the firearm. So it may be significant. It could be nothing at all, but the police, the Georgia Bureau of Investigation, who is handling this matter, apparently are going to investigate it and see if they cannot locate the person who wrote the card and determine if they were a witness or just somebody giving some general sympathy and empathy for the situation. Next on the docket, a woman who was shot and killed in her Louisville, Kentucky home by police executing a botched search warrant who forced their way in, surprising the woman and her boyfriend who thought the officers were burglars, have filed a lawsuit related to her death. The lawsuit was filed by the family of Breonna Taylor. She was an EMT worker, and she, along with her boyfriend, were home, and they thought that they were being burglarized, and the boyfriend fired in self-defense. The police officers executing the search warrant, 3 in particular, then blindly fired more than 20 rounds into the apartment. The police say they had knocked on the door several times and announced their presence as police who were there with a search warrant, which is kind of unusual since it was a no-knock search warrant. After forcing their way in, they immediately were met by gunfire. The boyfriend, Kenneth Walker, was asleep in the bedroom when the police in plainclothes and unmarked vehicles arrived at the house looking for a suspect who the police believed lived in a different part of the city and was already in police custody. As stated, the 3 officers entered the home without knocking and without announcing themselves as the police officers entered, which is a little different from the other statement that the police said that they, in fact, did announce their presence. Ms. Taylor and Mr. Walker woke up and thought that criminals were, in fact, breaking into their residence. Mr. Walker called 911 and police and said he'd opened fire and shot an officer. The police officers then proceeded to spray gunfire in the residence with a total disregard for basically human life. That's what the lawsuit alleges. Now, Mr. Walker apparently was legal for possessing a firearm in his home, and they say that he had a license. And what city still requires a license to have a firearm anywhere? Have they not heard of Supreme Court case law Heller? You can't do this, people. Ultimately, the police searched the house, and no drugs whatsoever were found. Both Taylor and Walker had no criminal history or any type of drug convictions. Miss Taylor's address was apparently listed on the search warrant based on the police department's belief that the drug suspect had somehow used her home address to receive mail, keep drugs, and apparently stash money there. They also alleged that Taylor's vehicle was seen in front of a drug house that they believed was known to the suspect. The 3 officers have been reassigned pending this litigation. Now, the irony of this is that the police go into the wrong house based upon bogus information that they prepared and presented to a judge. Miss Taylor was shot 8 times by the police, and Mr. Walker was arrested and charged with assault and attempted murder on a police officer when he believed that burglars were coming into the house to rob them. Some states have a Make My Day, where if you are in your home and you believe that you are in fear of death or serious bodily injury by an uninvited intruder, you can shoot to kill, including police officers. Now, I'm sure the officers are going to say qualified immunity. We were just doing our job. After all, the judge signed the warrant, so it's not really our fault, which is what they'll claim. But to prosecute the gentleman who reasonably believed that he was having a home invasion take place and shot at people in plain clothes, executing a no-knock search warrant, maybe there's something I'm missing here, but perhaps the Louisville, Kentucky Police Department, and hopefully I pronounced that, it's not Louisville, it's Louisville, will look at this and re-examine the charges in this particular case, because that just seems like something's not right unless there's something I'm missing. Next on the docket, a 32-year-old murder case is solved in Australia involving an American citizen. A man has been arrested by detectives investigating the murder of Scott Johnson, whose body was located near North Head more than 30 years ago. On the morning of December 10th, 1988, the body of Sydney-based American national Scott Johnson was found at the base of a cliff at Bluefish Point, near Manly's North Head. Scott was 27 at the time. A coroner's inquest in 1989 found Scott had committed suicide, with a second inquest in June in 2012 returning an open finding. The matter was ultimately referred to a third inquest, and in 2017, then the coroner, Michael Barnes, found that Mr. Johnson fell from the cliff top as a result of actual or threatened violence by an unidentified person who attacked him because they perceived him to be a homosexual. Following that final inquest, Police Commissioner Mick Fuller met with Scott's brother, Steve Johnson, to discuss the case before selecting a special team of detectives to investigate the circumstances surrounding Scott's death. In December of 2018, the government increased the $100,000 reward to $1 million before Steve announced a further $1 million reward this year. Following an extensive investigation, Strike Force Wellsford detective arrested a 49-year-old man at Lane Cove about 8:30 a.m. on May 12th. Steve's brother, who still lives in the United States, was notified of this, and Commissioner Fuller said that making that phone call this morning was, in fact, a career highlight. So on Tuesday, a gentleman by the name of Scott White, who's 49, was charged with the murder in connection with the alleged hate crime. And Mr. Scott White, who's given the presumption of innocence, even in Australia, has been refused bail at this point, and a plea has not yet been entered. So we've mentioned this before. These cold case units do work vigorously on these cases. I know it takes time. We all get impatient. You want to see results. But this shows that these victims will not be forgotten, and hopefully the family can have closure and justice will, in fact, be done. Next on the docket, a 5-year-old boy proves that dreams do come true. If you may recall, last week we talked about a 5-year-old who went on a joyriding trip in his mother's SUV. Apparently, the 5-year-old, Adrian Zamaripa, was pulled over by Utah Highway Patrol last week as he was spotted driving 32 miles an hour down Interstate 15 in the family's SUV. The troopers wanted to know where he was headed. Adrian, who barely made it 3 miles from home, told the trooper he had headed to L.A. to buy a Lamborghini with the $3 that he had in his piggy bank. Apparently, young Adrian has not been charged with any crimes in Utah, nor has a dependency and neglect case been opened up, basically saying maybe mom may want to supervise the kid just a little better. No, not here in this particular case. Only in America can you basically steal your parents' car, go on a joyride, endangering lives of people on the road everywhere. Do you then get called up by celebrity car agents, specifically a gentleman by the name of R.D. Whittington, who owns the luxury brand Wires Only. Well, apparently he flew Adrian and his family out to L.A. after the infamous stop and hooked them up big time. Apparently R.D. took the family out to Malibu where they visited luxury car dealerships, and the best part was apparently Adrian got to sit in a Ferrari, a Hummer, and apparently some other fancy rides. And apparently Shaquille O'Neal and Lil Pump showed up via FaceTime. Apparently young Adrian got to take a little cruise around LA and ultimately wound up at Jamie Foxx's residence and was given a little motivational speech to listen to your mother, do well in school, and don't steal cars. I think this story shows that dreams do come true. My only question is what do I have to steal so that I can get maybe some flights in a Gulfstream 6? Any suggestions? Any celebrities willing to take me on their G6, maybe so I don't have to steal something to do it? Because I don't think I would be treated as well as young Adrian would. If you have any suggestions, feel free to leave a comment. Next on the docket, our dumb criminal contestant of the day. Now, we're not trying to say that our dumb criminal contestant of the day is really dumb. It's just, that's what we call the segment. Some people don't like the name of it, but the reality of it, it just simply shows what crazy things people can do. And the story today takes us back to Mother's Day, and it involves a woman by the name of Sandra Webb. Well, apparently Miss Webb and her spouse had a little incident on Mother's Day. Apparently Miss Webb was upset at the victim because he bought her children flowers to give to her on Mother's Day. This apparently made Miss Webb quite angry. Miss Webb then allegedly threw the flowers at the victim while he was in bed and struck him with the bouquet. Webb is alleged to have also spit on her husband. Miss Webb, being the good, honest mother that she is, admitted to throwing the flowers but denied spitting whatsoever. She was ultimately arrested for domestic battery and was booked and released on jail Monday afternoon on her own recognizance. It's unclear exactly why she would be upset that her husband bought the flowers for the children to give to her on Mother's Day. Not really sure. It's also unclear whether Miss Webb will be able to return home. If she was allowed to return home, wouldn't you love to be a fly on the wall for that conversation? Mr. Webb must be thinking, I thought I was doing a good job. I got flowers for the kids. It's not like you're my mom, Sandra. What did you want from me? Well, geez. Some days you can just never win. And in this particular case, Sandra Webb lost. So for the instrumentality that she used, she has been awarded the dumb criminal contestant of the day. At least you could have used something that was actually going to hurt him if you were that upset about it. Not that we're saying any violence is necessary, but you know what I'm saying. Now, for those of you who may have missed it, last night we live streamed on Facebook because we're still in YouTube detention, at least until June 3rd. So we'll continue to do that next Tuesday at 6 p.m. until we can once again go live, but we'll still do it on Facebook as well because we have that technology apparently. We also put that up. Hopefully you enjoy it. We also have Patreon members increasing rather quickly, and we're going to do something kind of special for them. And frankly, we're going to probably do a segment whereby we talk about cases not only that they want to talk about, but go much more in depth, and probably cases that, frankly, YouTube would find reprehensible and that we probably wouldn't want to talk about in that kind of detail. So we have that coming on. And as always, if you would like to get any of the merch without being a dumb criminal contestant and winner as a dumb criminal contestant, you can go to the link below, order your mugs, t-shirts, and other items, and they will be to you shortly. You don't have to buy any of it, but if you do, thank you in advance. We know you have lots of things that you could be doing. The fact that you take the time to watch our little show is greatly appreciated. Thank you for watching. Have a great day.